This was January 2nd.
Thank you, Bob Kincaid, and welcome to the third edition of the Virtual Center for the Study of the Constitution and Civic Responsibility of this first full week in November. It is a pleasure to be with you. It is very, very kind of you to give some of your time. I know that there is a lot of different events and issues competing for your time, and it becomes very valuable. And I want you to know that I appreciate that. We do appreciate that, and that kind of basically commits us to the idea that we hope that these visits to the virtual center are meaningful and productive and worthwhile for you.
No, really.
We invite you to participate actively in the program by giving us a call. We have a phone number, area code 304-658-3333, and that'll get you directly on the air. And again, I want to encourage you to do that. Not only will I appreciate hearing from you, but our other listeners will as well. If you would like to communicate with me directly via email, then please feel comfortable doing that. My email address is waobrien906@gmail.com. That's waobrien906. O'Brien is IEN 906@gmail.com. Yesterday, just a comment or two on the world we live in. I guess that's the best way to introduce it. You know, we had a couple. As you know, we had a couple of big elections yesterday. The principal ones being in New Jersey and Virginia. We also had important mayoral races, one in New York, one in Boston. And the one in Boston, of course, I'm particularly interested in because I have family there and I spent so much time there. But Mayor Menino has been mayor of Boston for so long that this is really traumatic for the city of Boston. This is the first time in many, many years that they've had somebody other than Mayor Menino. And if you can remember back to the events surrounding the marathon bombing situation in April in Boston, the events at the memorial events at the church and things like that, you may remember seeing Mayor Menino. At that time, as I recall, he was on crutches, and but he did make it a point to he broke his leg, from as I recall, and he made it a point to come to these events. And the popularity of this man, it's not related to party. Everybody seems to have been very. It's a tough row to hoe to replace him, I guess is what I'm saying, because he's been very, very popular and apparently very, very successful in terms of governing the city. So, but anyway, the one in Virginia was particularly interesting. Terry McAuliffe was predicted in all the polls to win big. He won, but he didn't win big. He won by about 3 percentage points, as I recall from this morning's view of the election results. And again, I think what that suggests is that the Tea Party supporters of the losing candidate, Ken Cuccinelli, can take some solace in the fact that there was a fairly strong turnout for him in the face of the fact that Virginia has so many federal employees in Northern Virginia, and they clearly swung the election because with 81% of the vote in and Northern Virginia still to come, Terry McAuliffe was actually running behind. So he won the election with the Northern Virginia vote. Those are federal employees who undoubtedly were reacting to the shutdown and the sequester and all the other things that Republicans and Tea Party proponents have been pretty much responsible for. And I think it cost him the election. It was quite close. On the other hand, Governor Christie in New Jersey won by 22 percentage points. So He's now being touted as somebody to be taken very, very seriously in the upcoming presidential election of 2016, because he has a very strong, solid, middle-of-the-road following. He is very popular with working Democrats, with union people, and so again, I think it was a very telling election. Of course, everybody's looking for indications or signs as to what might happen in 2016, and of course, the unknown factor right now is what Hillary Clinton's going to do, and of course, she at this point claims that she has not made up her mind. So, but anyway, and I don't want to get too much into politics, but I think any more than we need to here. But I really think that it's very important to pay attention and keep abreast of what's happening. I was particularly, as we indicated on yesterday's program, I was particularly interested in Ron Paul's appearance in Richmond on Monday night in support of the Republican candidate Cuccinelli, and his call for Virginia to nullify Obamacare. And I mentioned this on the air yesterday, and I'm not going to repeat it now, but one of the things that struck me is that when Calhoun was successful, John C. Calhoun was successful in getting a nullification vote through the South Carolina legislature in 1832, the President of the United States at that time was Andrew Jackson. And as we mentioned yesterday, Jackson was ready to go to war with South Carolina over that vote. In other words, to take on the Union, take on the Constitution that directly, which is what nullification does, was considered to be tantamount to an act of war, at least in the mind of Andrew Jackson. Of course, part of this is Jackson's personality, true. But the fact of the matter is, had Jackson, were Jackson president now, it is likely that Ron Paul would be incarcerated after the speech that he gave Monday night. I mean, that's just an indication, it seems to me, of how serious this is. And in class this morning, I was mentioning to students the fact that while they are currently involved in reading about nullification in the 1830s with John C. Calhoun, it is important to recognize that the issue continues to live today. And I shared with them the speech by Ron Paul on Monday night as an example of that. So, in other words, the issues that history teaches us are very, very relevant. And to kind of go back for a second to where we ended yesterday's program, and I believe this is very, very important. All of this is based on the assumption that the American voting public, the American electorate, is rather ignorant on some of these issues. Their knowledge of history, of their own nation's history, is so weak that these people feel very, very comfortable in dredging historical tidbits, pieces of information out of context, and using them in order to further their current political agenda, whether in fact they are being true to the information they are using or not. I think it's very, very important, because the assumption is that if you use the right names like Jefferson and the founders and Hamilton, and if you use the right names, you can pretty much say anything you want and attribute it to them, and it becomes credible. And I think while that bothers me because of the disservice it does to the founders and to history itself, it also bothers me as a citizen, because it's incredibly unkind to the voting public, to the citizens of the United States. It basically suggests that the citizens of the United States are so poorly informed on issues that matter that you can tell them anything and they'll believe it. Unfortunately, I think more and more of our political campaigns are being conducted on that kind of an assumed foundation. More and more you begin to see that people are doing that they are basically taking the general ignorance and unawareness of the electorate as a given, and they are conducting their campaign appropriately based on that assumption. And it's not just in election campaigns. I would suggest to you that if you think back to the work we did here at the Virtual Center on Mark Levin's book, The Liberty Amendments, you can recall 2 or 3 places where there's a little bit of interpretational license being taken there, where things are being stated as fact about the past and about the founders that are not quite accurate, not quite valid. The one that I'm specifically thinking about is Article 5 on amending the Constitution. You know, that's the one that sticks in my mind right now. Because as we mentioned yesterday, in fact, that there are 2 ways to amend the Constitution. One from the central government down to the states, and the other one as a result of a convention called by the states, requested by 2/3 of the states. And that second approach has never been used, and that's the one that Mark Levin is pointing to in his Liberty Amendments. And there's no question, and while we're here, you know, one thing kind of raises another thing. But in listening to some of the commentary about yesterday's elections in the media this morning, you know, in one newscast after the other on CNN, CBS, and whatever, one of the things you begin to pick up by commentators, which I think is very, very relevant, and they're saying it, I don't think that they realize how relevant it is, that more and more we're focusing on state contests rather than national contests. Most of what's happening in the nation that's politically relevant is happening on the state level, not on the national level. In fact, the national government, as we know, has become seemingly quite dysfunctional. And what is happening is that the action is on the local and the state level. And I would suggest to you that's where the calling of a constitutional convention will come from. And so the fact that these commentators are recognizing that, looking specifically at the elections yesterday in New Jersey and Virginia, it's very obvious that the contest is being fought out on a state-by-state level. And what's happening state by state, as the entire South has been taken over by Republicans, legislatures and governorships, districts have been redrawn in such a way that re-election of the right people, and these are caucus decisions, these are not convention decisions in many cases. In other words, the architect of the party, the architects of the party are selecting the candidates in what have become safe districts. It almost is coming to the point where they can't, once they're in, you can't get them out. And so these are becoming locked-in states, and it's happening one by one by one. And I would suggest it is extremely important. That is exactly what Mark Levin is talking about in his Liberty Amendments, is going through the states and calling a constitutional convention there, you know, in that direction for the first time, using that strategy. And in his book as background, he basically he suggests that the preferred mode of amending the Constitution at the convention was from Congress down, and that the state convention approach became part of Article 5 only at the last minute, only by happenstance, only by accident. that in fact it was he paints it kind of as if the convention strategy was kind of a sop thrown to the states in order to get them to be much more amenable to the Constitution as the vote for ratification approached. Fact of the matter is, if you look at the convention debates, that strategy is the initial one for ratifying amendments to the Constitution. And Madison and the other Federalists came in at the 11th hour and added the legislative approach, where if 2/3 of both houses of Congress approve an amendment, then it is submitted to the states for their consideration and ratification. And if ratified by 3/4 of the states, it becomes part of the Constitution. Mark Levin is suggesting that was the initial strategy at the convention of Federalists. In other words, the strong central government, and that the states initiating change in the Constitution was kind of an afterthought. The fact of the matter is, it was just the reverse. It was just the reverse. And the fact that the state convention approach hadn't been used yet is in part a result of the Federalist Papers, because so much attention was given to the danger of another constitutional convention and the fear that everything gained would be lost once you opened that can of worms. Once you opened that, that Pandora's box, if you will, you'd never get it closed again. And I think that's what we're looking at right now, because getting that Pandora's box open is what this is about, the calling of a constitutional convention. So I think it's very, very significant. These issues are extremely significant. Excuse me. Yesterday we were talking about the Federalist Papers, and I had kind of at the end of the program suggested a preview of where I'd like to take us today while we're in the Federalist Papers. We looked at Federalist number 1, we looked at Federalist number 9, and then we looked at Federalist number 39 on the issue of Republican government, and the extent to which the debate about Republican government focused on the writings and the philosophical thinking of Montesquieu in his Spirit of the Laws. Political scientists, government textbooks will tell you where Montesquieu is quoted most in the areas of American government is on the idea of separation of powers, the division of government into specific branches, legislative, executive, and judicial. And this, it seems to me, is an important place to go. And part of the reason for that is because that's where Madison goes. More important than that, the division of government into various branches is part of the internal system of checks and balances, which Madison believes will enable the Constitution to work. That what you do is you make the internal system so complicated by making sure that each branch has some level of control over the others, an ability to check the others, that you make hasty decisions that were not thought out very, very difficult. By definition, you create a political system which makes the act of governing itself from the national level very difficult. It's tough to get anything through that maze, and that's Madison's strategy. That's what he talks about in Federalist number 10, and that's what he specifically talks about in Federalist number 51, which we have looked at before, and which I think we probably need to revisit again. If you look at Federalist Papers, the 4 or 5 Federalist Papers leading up to 51, I'm talking about 47, 48, 49, and 50, and then 51. Every one of them is based on the idea of separation of powers. So what we're saying then is that 5 of the Federalist Papers are devoted to the idea of checks and balances, the idea of separating power in different branches of government. And this goes all the way back to Europe. Without going too far, it's based on the old idea that society was organized in certain ways, and that the only government that could work is a government that reflected the reality of the way society was organized. In the executive branch, that was the king. The legislative branch was, in England, in Great Britain's case, it was Parliament. And Parliament created the model of dividing the legislative branch into 2 parts: the House of Commons and the House of Lords. I don't know whether you've ever thought about it, but the very names of those two houses of Parliament are very significant. The House of Commons and the House of Lords suggests what the mission or the intent of each of those 2 houses was about. The thinking was that the voting public, which was of course very, very limited in Great Britain, would gain access to the government through the House of Commons, through elected representatives in the House of Commons. But the check on the House of Commons was in the hands of the Lords, the upper classes who were represented in the House of Lords. And theoretically, the Lords would check to make sure that nothing was coming out of the lower house that was dangerous to society, to the organization of society, to the economy, to the nation's power, or whatever. In other words, the upper house, the House of Lords, would act almost as a filter for what was being initiated in the lower house, with the intent that it would move up, that it would move on to the king for a final decision. And basically what comes out of this is the idea, what Montesquieu writes in A Spirit of the Laws, is the idea that popular government, republican government, can only work when power is internally divided in such a way that all power is not in the same hands. And so Montesquieu is addressing the issue of separation of powers. And that's in the government textbooks that you see in grade school. When Montesquieu's name's mentioned, it's usually associated not with Republican government per se, but with the idea of separation of powers and the division of government into branches. And the fact of the matter is, the opponents of the Constitution are criticizing the Constitution because of the interaction possible between the different branches of government. And they go back to Montesquieu, and they basically are relying on Montesquieu in order to make the case for separation of powers. And part of the argument that the new Constitution is creating a consolidated national government over the states and the people, rather than a government of the states and of the people, is in part because of the internal checks and balances that are built into the system. For example, the president has veto power over legislation coming from the legislative branch. But the House of Representatives has the power of the purse. It controls the money. Money bills must emanate from the House of Representatives. So consequently, the House of Representatives can check runaway actions by the president by denying him funding. After 2016, we may not be able to successfully continue to refer to the president as a him. That's another issue. But the idea being that the House's check on executive power is its control of the budget, the control of the finances. And of course, this is what we've seen with Obamacare. The fact that the House, the Republicans in the House, have effectively been trying to derail the program by refusing to fund it. So the president can veto what the House does. The House can have a check on what the president does. The members of the courts, because of their power to rule on the constitutionality of legislation, the court's ability to strike down as unconstitutional pieces of legislation gives the courts check on both branches, because they basically say what the Constitution is, what the law is. And even dividing the legislative branch into two branches, the House of Representatives and the Senate, which of course models the House of Commons and the House of Lords in England, the basic idea is, the thinking, the intent is that the Senate will exercise the same role within the American government, within the U.S. government, as the House of Lords did in England. In other words, it will be kind of the upper class check. The Senate will be comprised of the most staid, well-known people in the community. And while the Senate is part of the legislative branch and must agree to every piece of legislation before it can become law, the state legislatures elect the members of the Senate, while the people elect the members of the House. So in other words, if you look at the internal structure of the Constitution, there's an awful lot of interaction and overlap between the branches. And the opponents of the Constitution, the anti-federalists, focus on these areas of overlap as their way of arguing that the Constitution of the United States does not preserve the separation of powers that Montesquieu argued was so necessary, but in fact obliterated it. And consequently, what we were going to end up with was a consolidated national government rather than a federal government, rather than a government where powers would be divided between the states and the federal government. And so Madison is almost duty-bound to take up the issue of separation of powers, because so much of the criticism of the Constitution is focused there. So it stands to reason that in a series of papers designed to explain away or to refute allegations against the Constitution, that's what the Federalist Papers are, it stands to reason that at least one of those papers would be focused on the separation of powers. And indeed, 5 of the Federalist Papers are so focused. And that's kind of where I thought we might gain some advantage by going today, is looking at the way Madison handles the criticism being leveled against the Constitution by its opponents that the Constitution violates Montesquieu's principle of separation of powers. And the first time that this issue is addressed is in Federalist number 47. These are all written by James Madison. I'm taking these. I've got the Federalist Papers here in this huge book. It's like a Sears Roebuck catalog. And so, you know, if you hear a lot of shuffling and stuff in the background, it's the fact that I'm holding this book, which weighs about 8 pounds, and I'm shuffling around and trying to read it and and direct conversation into the microphone at the same time. So I'm apologizing ahead of time for that. Madison introduces 47 by suggesting that a major change in approach is beginning in the Federalist Papers. Madison says that in his opening line in number 47, having reviewed the general form of the proposed government and the general mass of power allotted to it, I proceed to examine the particular structure of this government and the distribution of this mass of power among its concomitant parts. That's the first paragraph of Federalist number 47. So Madison is telling us that 47 begins a change in focus. That up to this point, most of the attention has been focused on the general form of the new government under the Constitution and the various powers allocated to the different parts of it. Now what he's talking about is the overall internal structure of that government, and of course he's moving into separation of powers. And as he must, he goes immediately to Montesquieu. And he says, the several departments of power are distributed and blended in such a manner as at once to destroy all symmetry and beauty of form, and to expose some of the essential parts of the edifice to the danger of being crushed by the disproportionate weight of other parts. He's talking about the need for separation of powers. And he says the accumulation of all powers, legislative, executive, and judiciary, in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, must justly be pronounced the very definition of tyranny. It doesn't matter how you choose the people who occupy these different branches of government. If it all ends up in the same hands, if power ends up in the same hands, whether it's elected, whether it's appointed, whether it's inherited by birth or blood or anything else, the fact of the matter is, by putting all power in the same hands, you have effectively defined tyranny. And so consequently, the only way to avoid that tyranny is to separate that power into different departments or different agencies, different branches of government. And then he goes to Montesquieu. And he points out that to Montesquieu, the best constitution in existence for the reasons of separation of power is the British Constitution. In fact, Madison says, raising what he does is put to rest any question that Montesquieu is a fan of, an advocate of, a supporter of the British Constitution as the best in existence. Madison says the British Constitution was to Montesquieu what Homer has been to the didactic writers on epic poetry, the perfect model. Montesquieu viewed the Constitution of England as the standard. That's a quote from Madison's Federalist number 47. And then Madison goes through the very nature of separation of powers in the British Constitution. The monarchy, the House of Commons, and the House of Lords. And points out that in each of those, sectors of British society are represented. And so it seems to be the most appropriate way to organize your government, because each branch represents a particular segment of the population at large. The monarchy and the nobility that supports the monarchy represents the landed aristocracy of England. And within within the House of Lords is the representation of that aristocracy over the legislative behavior of the House of Commons, which is the branch that has the most direct link to the people. And then you have the whole judicial system of Great Britain, which is separate and unique, based on the unwritten British Constitution and the traditions associated with common law. And because of that separation, Montesquieu believes that that's the model that all republics must follow in order to be successful. And I'm going to quote Madison here in Federalist number 47. Madison says, "From these facts by which Montesquieu was guided, it may clearly be inferred that in saying, quote, there can be no liberty where the legislative and executive powers are united in the same person or body of magistrates, or, quote, if the power of judging be not separated from the legislative and executive powers," unquote. Now back to Madison. He did not mean that these departments ought to have no partial agency in or no control over the acts of each other. His meaning, as his own words import, and still more conclusively as illustrated by the example in his eye, can amount to no more than this, that where the whole power of one department is exercised by the same hands, which possess the whole power of another department, the fundamental principles of a free constitution are subverted. What Madison is doing here is engaging in shrewd political strategy. He pays homage to Montesquieu as the best argument in support of separation of powers. And he gives credit to those opponents of the Constitution who cite Montesquieu as the standard for the principle of separation of power. Then he points out that for Montesquieu, the standard, the model Constitution, was the British Constitution. And then he goes through and begins to show how, even within the British Constitution, the branches of government are not totally separated from each other, but rather they interact on a regular basis. Madison says, on the slightest view of the British Constitution, we must perceive that the legislative, executive, and judiciary departments are by no means wholly separate and distinct from each other. The executive magistrate forms an integral part of the legislative authority. He alone has the prerogative of making treaties with foreign sovereigns, which, when made, have, under certain limitations, the force of legislative acts. All members of the Judiciary Department are appointed by him, can be removed by him on the address of the two houses of Parliament. And he goes on and on. So what he's showing is that in the British Constitution, which to Montesquieu is the best, there is interaction and interrelationship between the various branches of government. What Madison has successfully done then is he has kind of disarmed the critics of the Constitution who are focusing on the interaction of the different branches of government as a reason to not support the Constitution, because they claim it violates Montesquieu. Madison's argument here is, no, it does not. Montesquieu himself believed that the British Constitution was the best Constitution, and even it involves the interaction of the different parts in various and sundry ways. So what Madison has effectively done is disarm the critics who are trying to use Montesquieu to criticize the Constitution by suggesting that even in the optimum British Constitution that Montesquieu is so fond of, the branches are not totally separated from each other, but there's constant interaction and involvement, one branch with the other. Madison goes on. And that's when, after that, it's after that analysis of the British Constitution that Madison says, from these facts by which Montesquieu was guided, it may be clearly inferred that in saying there can be no liberty where the legislative and executive powers are united in the same person, a body of magistrates, or, another quote from Montesquieu, if the power of judging be not separated from the legislative and executive powers, Madison points out, he didn't mean that these departments ought to have no partial agency in or control over the acts of the other. His meaning, as his own words import, and still more conclusively as illustrated by the example in his eye, can amount to no more than this. Where the power is in the same hands, you get a violation, you get tyranny. But you don't go so far as to mean that the branches of government can have no contact with each other. So what Madison has done is conduct an analysis of the British Constitution to suggest that even it, the one that Montesquieu believes is the best, does not totally separate one branch of government from the other. Consequently, by doing that in the Constitution, we haven't violated Montesquieu at all. What we're doing is very consistent with what the British Constitution does, and Montesquieu believes the British Constitution is the best one of all. Then Madison goes on and really drives the point home even more forcefully. If we look, he says, at the constitutions of the several states, we find that, notwithstanding the emphatical and in some instances unqualified terms in which this axiom has been laid down, which is separation of powers, there's not a single instance in which the several departments of power have been kept absolutely separate. Now Madison has moved away from the British Constitution and he's moving into the constitutions of each state. And he points out that some of these states, not all of them, but some of them, openly state that separation of powers is the most important principle that makes the government work and remain as a republic. The first one he addresses is New Hampshire. And the reason he addresses New Hampshire is because it's the last constitution written. And he said, it seems to have been fully aware of the impossibility and inexpediency of avoiding any mixture whatever of these departments, and has qualified the document by declaring, in other words, New Hampshire has put right in its constitution the following, that the legislative, executive, and judiciary powers ought to be kept as separate from and independent of each other as the nature of a free government will admit, or as is consistent with that chain of connection that binds the whole fabric of the Constitution in one indissoluble bond of unity and amity. So the New Hampshire Constitution declares that as much as possible, as much as feasible, the branches of government in the New Hampshire Constitution are to be kept separate. Then he goes on to show that even in that Constitution there's interaction and reaction and involvement, one branch with the other. Then he moves on to Massachusetts, and he points out that Massachusetts also has observed the importance of separation of powers. Then he goes through an analysis of Massachusetts Constitution to show that there is interaction constantly between the branches of government in the Massachusetts Constitution. Then he goes on to New York, New Jersey. He points out that the Constitution of New Jersey has blended the different powers of government more than any of the others. Then he goes to Maryland and Virginia and North Carolina and Georgia. And that's the bulk of Federalist number 47, is Madison's effort to show that in every state constitution while there is an openly verbal commitment to the principle of separation of powers, the fact of the matter is the authors of these constitutions realized that in order to protect liberty they need to be separated, but in order to function as a government they need to be interactively related, connected, somehow. You can't have them totally separate. Otherwise, you have a total breakdown in the ability of government to govern. I think we're kind of seeing that in Washington right now, aren't we? And then Madison brings Federalist number 47 to a close. In citing these cases, he says, in which the legislative, executive, and judiciary departments have not been kept totally separate and distinct, I wish not to be regarded as an advocate for the particular organizations of the several state governments. That's not my point. I am fully aware, he says, that among the many excellent principles which they exemplify, they carry strong marks of the haste and still stronger of the inexperience under which they were framed. In other words, I'm not criticizing these state constitutions. They were drawn up overnight. They were drawn up very quickly during the War for Independence. Most of the people in these states didn't have the experience of writing constitutions to begin with, so of course they're not perfect. Consequently, he says that the fundamental principle under consideration, which is separation of powers, has been violated by too great a mixture and even an actual consolidation of the different powers in some of the states. In other words, what he's pointing out is, how can you criticize the new Constitution because it's not perfect separation of powers when none of the state constitutions are successful, even though they openly say in black and white that they are committed to the principle of separation of powers? They all violate it. The British Constitution violates it. So consequently, what he's done is disarm the critics who are criticizing the Constitution because the separation of powers is not perfect. And Madison closes with the following: what I have wished to evince is that the charge brought against the proposed Constitution of violating a sacred maxim of free government is warranted neither by the real meaning annexed to that maxim by its author, nor by the sense in which it has hitherto been understood in America. This interesting subject will be resumed in the ensuing paper. What he's suggesting is we'll continue in the next Federalist paper, number 48, further consideration of this idea of separation of powers. In other words, what he's doing is refuting the critics of the Constitution and their effort to cite Montesquieu as evidence that the Constitution should be defeated because it violates Montesquieu's principle of separation of powers. Madison is pointing out that every state constitution, in fact, violates separation of powers. And Madison's position is going to be, I'm going to give the plot away here. What he's going to come to toward the very end is the idea that the reason we need the Constitution in the first place is because in state after state, the legislative branch has been able to take power away from the other branches. The legislative branch is overwhelming the other branches. And of course, we know that the legislative branch is the branch closest to the people. Consequently, majority factions have been able to organize and issue instructions to their elected representatives on how to vote. In other words, the weakness of the state constitutions, according to Madison, is that they are not really following Montesquieu's principle of separation of powers. They are making it possible for legislative branches, for legislatures to get control of government. The Pennsylvania Constitution, which is the most radical of all, Madison believes, only has the legislative branch, only one house, the legislature. And so Pennsylvania is clearly a constitution that lays all power in the hands of the legislature. But Madison points out in all these other states that the legislatures have been able to get it. The constitutions that were written during independence were much alike. And what that means is they tended to weaken the power of the governor and strengthen the power of the legislature. And of course it makes perfect sense why they would do that. Because most of their problems in the colonial period came from royal governors, came from the executive branch of government. So naturally, when they're drawing up their own constitutions, they weaken the power of the governor tremendously, and they make the governor as dependent as possible on the legislature. And the other side of that coin is they do everything possible to put as much power as possible in the hands of the legislature, because that's the one closest to the people. That gives the people more control and more oversight over government. That's what republicanism is about, they believe. So in other words, Madison is taking the critics who are criticizing the Constitution for a violation of the principle of separation of powers, and he's using that criticism against the states themselves under the Articles of Confederation. And he's basically saying, if you're committed to that principle, then look at your own state constitutions. This is the reason we need the Constitution, is because separation of powers in the states has been violated by an excess of power in the legislatures, which means an excess of influence by the masses of the people. So by putting power in that branch of government which is closest to the people on the state level, and weakening the government, so that the governors, so that the governor can't veto anything, effectively means that if the people get control of their own representatives, they've got power. Consequently, they can tell the legislature to pass paper money laws, stay laws, installment laws, legal tender laws, making crops payable for debts and taxes, and literally driving the creditor element of society nuts. And so what Madison has done in 47 is basically use the constitutions of the states themselves to make the point that separation of powers is in trouble in America, not because of the new Constitution, but because of the state constitutions which make the Constitution necessary. And then he says at the very end, this interesting subject will be resumed in the next paper. I'm not going to get into the issue of how interesting this subject is. I think it's extremely complicated. It's rather abstract. It's incredibly important to understanding the nature of the political process in America. 48 continues Madison's discussion of separation of powers. And in 48, he addresses much more directly than he does in 47 the extent to which the major challenge to separation of powers in America is in the states. The reason we are here writing a new Constitution, Madison is saying, is because the structure of the state constitutions has enabled the legislative branch to obliterate the other branches. Consequently, what we are witnessing in state after state are examples of legislative tyranny. The majority of the people are controlling the legislature and telling it what to do, and the legislature is doing it, and there's no check beyond it. Consequently, Madison is basically saying that the Constitution is necessary in order to eliminate the degree of democracy that exists within the states under the Articles of Confederation. That's what he's saying. And so in 48, he talks specifically about the extent to which it's the legislative branch more than any other that jeopardizes a state's commitment to separation of powers. The states say they are committed to it, but in day-to-day practice, they can't make it work. Power tends to go to the legislative branch. He says, a respect for truth obliges us to remark that they seem never for a moment to have turned their eyes from the danger to liberty. They seem never have recollected the danger from legislative usurpation of power. It doesn't matter what kind of government you're talking about. A hereditary monarchy. In a hereditary monarchy, the executive branch of government, the executive department, is very justly regarded as the source of danger, Madison says, and watched with all the jealousy which a zeal for liberty ought to inspire. In a democracy where the multitude of people exercise in person the legislative functions, we have legislative tyranny. And then he says, in a representative republic where the executive magistracy is carefully limited, both in the extent and the duration of its power, and where the legislative power is exercised by an assembly which is inspired by a supposed influence over the people, what we are seeing is the need to take steps against what he calls the enterprising ambition of this department. The legislative department derives a superiority in our governments from other circumstances as well. He talks about the size of the legislatures. They're bigger, they have more supporters. They get more support out in the general community. They are closest to the people. In other words, they have so many advantages over the executive departments and over the judiciary departments. So basically, now what he's done in Federalist 48 is he has moved to the idea that controlling legislative tyranny is really the greatest threat that the violation of the principle of separation of powers is brought about. And he's going to use two examples, and the first one is Virginia, and the second one is Pennsylvania. I'm going to use the one with Virginia because his whole argument is based on a quote from Thomas Jefferson. Jefferson was a governor. So Jefferson knows from first-hand experience what happens when a governor tries to govern working with a legislature which is designed to take as much of his power as possible and to limit as much as possible the power of the executive branch of government. So Madison quotes Jefferson here. The authority in support of this, he says, is Mr. Jefferson, who, because his other advantages for remarking the operation of the government, was himself the chief magistrate of it. In order to convey fully the ideas with which his experience had impressed him on this subject, it will be necessary to quote a passage of some length from his very interesting Notes on the State of Virginia, page 195. And then he incorporates this extensive quote from Thomas Jefferson. And Thomas Jefferson is going to, in this quote, make it perfectly clear that the greatest threat to liberty in Virginia is legislative tyranny. With that promise, we have reached the top of our hour, so let's let's pause and take a 5-minute break, and we'll come back with Jefferson's quote. And then we'll move on to Federalist 49 after that. We won't necessarily have to look at Pennsylvania. I think you'll get the point just by looking at Virginia as to what Madison is trying to do. Absolutely brilliant political strategy. But again, I have to say that those people who argue, oh, we read the Federalist Papers in school, I would suggest to you that that's probably not true. You're listening to the Virtual Center for the Study of the Constitution and Civic Responsibility. I'm Bill O'Brien, and after a 5-minute break, we'll be right back. Please stay with us. Thank you, Bob Kincaid, and welcome to our second hour of this Wednesday edition at the Virtual Center for the Study of the Constitution and Civic Responsibility. If you're just joining us, welcome. If you've been with us, you've had a pretty intense reading treatment of Federalist number 47, and we've just begun looking at Federalist 48. We're looking at the issue of separation of powers, and basically what we're talking about here is Madison's effort to disarm those critics of the Constitution who claim that the Constitution will create a consolidated national government and in the process will destroy the principle of separation of powers, which was so important to Montesquieu in order to protect individual liberty. The idea of separating powers was considered to be a key to protecting individual liberty from government tyranny. And so consequently, by criticizing the Constitution for the interaction of different branches, critics are into a very vulnerable area for Madison and those Federalists who support the Constitution. So Madison is duty-bound to deal with the principle of separation of powers, and he does so in a series of 5 Federalist Papers, beginning with 47 and ending with 51. And so in the first one, he defends the principle of separation of powers, and he points out a reverence for Montesquieu and alludes to Montesquieu's reverence for the British Constitution as the model constitution for the protection of individual liberty and the preservation of a republic. Then he points out, by going and looking carefully at every one of the state constitutions, Madison points out that every state constitution violates separation of powers. So in effect, he's by implication he's saying, so what are you criticizing the Constitution for? State constitutions up and down the Union are violating the principle of separation of power. Even those constitutions that openly state reverence for it violate it. And Madison's point is that the Constitution of the United States is necessary, in part, Madison believes a major part, because of the violation of the principles of separation of power on the state level. That's why we're here, he's saying. Absolutely brilliant political strategist at work here. We welcome you to the program, to this our second hour, and invite you to participate actively in the program by making a call, a comment. You can comment on this whole idea of separation of powers. You can comment on Madison's strategy, whether you think it was successful or not successful, or whether you believe that it would work today or not work today. I would suggest to you that that there's an awful lot here for reflection, thought, and discussion. And that's really what the idea of the Virtual Center was from the get-go, is an effort to get into this stuff and explain the basis and the principles of the American political system and the Constitution which defines it in ways that are meaningful and make sense to people, so that the result is that we are contributing to the education of the electorate. That's the goal. Our phone number is area code 304-658-3333. That's 304-658-3333. My email address, if you'd like to communicate directly with me on some of these issues, is waobrien906@gmail.com. waobrien906@gmail.com. We left our last hour with Madison introducing an extensive quote by Thomas Jefferson from Jefferson's Notes on the State of Virginia. And Madison is speaking from his experiences as governor of Virginia. And he's addressing the issue of legislative tyranny. In other words, Madison has made the case in Federalist 48 that it's legislative tyranny more than anything else. It's legislative usurpation of power in these state constitutions that is the major reason why we need a constitution in the first place. And while he went through each state constitution in the previous paper in 47 to show how each one of them blended the three branches of government and violated the strict adherence to the principle of separation of power, now he's going to focus on two states specifically, Virginia and Pennsylvania, as examples of how legislative superiority over the other branches has produced the problems that bring us here. And in dealing with Virginia, he relies on this quote from Thomas Jefferson, and he mentions that it is a lengthy quote. So if I may, Jefferson, all the powers of government, legislative, executive, and judiciary, result to the legislative body. The concentrating these in the same hands is precisely the definition of despotic government. It will be no alleviation that these powers will be exercised by a plurality of hands, and not by a single one. 173 despots would surely be as oppressive as one. What he's dealing with here is the idea that popular government is not going to be oppressive of people's liberties. Only monarchies are. And what he's saying is that 173 individual despots can be as oppressive as one. Let those who doubt it turn their eyes on the Republic of Venice. As little will it avail us that they are chosen by ourselves. An elective despotism was not the government we fought for, but one which should not only be founded on free principles, but one which should be not only one. Excuse me, I'm messing this up here. An elective despotism was not the government we fought for, but one which should not only be founded on free principles, but in which the powers of government should be so divided and balanced among several bodies of magistracy as that no one could transcend their legal limits without being effectually checked and restrained by the others. For this reason, that convention which passed the ordinance of government laid its foundation on this basis, that the legislative, executive, and judiciary departments should be separate and distinct, so that no person should exercise the powers of more than one of them at the same time. But no barrier was provided between these several powers. The judiciary and executive members were left dependent on the legislative for their subsistence in office, and some of them for their continuance in it. If, therefore, the legislature assumes executive and judiciary powers, no opposition is likely to be made, nor if made, can be effectual, because in that case they may put their proceeding into the form of an act of assembly, which will render them obligatory on the other branches. In other words, legislatures make laws. All they have to do is pass a law making what they're doing legal, and it disarms the other branches. They have accordingly, in many instances, decided rights which should have been left to judiciary controversy and the direction of the executive during the whole time of their session is becoming habitual and familiar. In other words, his experience in Virginia is that the legislature, on occasion after occasion after occasion, finds a way to disarm the other branches and to assume the bulk of the power in its own hands. And if there's any challenge to it, they merely pass a law legitimating what they do. In other words, now it's the law. You have to obey it. And so for Madison, he goes from here directly into Pennsylvania. Because from his point of view, Jefferson has said exactly why he's writing this Federalist paper. Legislative tyranny, legislative despotism. And of course Jefferson makes the point that despotism is despotism, whether it's in the hands of one person or it's in the hands of 173 people. It's still despotism, it's still oppression, it's still a violation of individual liberty. Madison then goes on to Pennsylvania, and he talks in Pennsylvania about the creation in 1783 and 1784 of a council of censors, which was assembled in these years. Part of its duty, as marked out by the Constitution, was to inquire whether the Constitution had been preserved inviolate in every part, and whether the legislative and executive branches of government had performed their duty as guardians of the people, or assumed to themselves or exercised other or greater powers than they were entitled to by the Constitution. That's the charge of this group, this body of censors. What he points out, I won't take the time to read it, but what he points out then in Pennsylvania is that the members of this board of censors, which is supposed to check on the Constitution of Pennsylvania and make sure that it's working, is made up of the very same people from the legislature who violated the Constitution in the first place. In other words, they're being asked to judge their own behavior. And of course they never find anything wrong. So his point is that even the check on violations of the Constitution is being conducted by the same people, representatives of the same people, who are violating that Constitution. So what Madison has done in Federalist number 48 is make it a point that while separation of powers is being compromised in every state, he has used Virginia and Pennsylvania, to make his case that legislatures in every one of these situations are grabbing power away from the other branches. They are destroying the principle of separation of powers. So what Madison has done then is totally disarm the critics who are arguing that the Constitution violates the principle of separation of powers. Madison points out the states are the ones that are violating it. That's why we need the Constitution in the first place. And then Madison goes on in 49 to a suggested remedy proposed by Thomas Jefferson. And of course Madison is very, very cordial to Jefferson. And he says the author of the Notes on the State of Virginia, quoted in the last paper, has subjoined to that valuable work the draft of a Constitution, which had been prepared in order to be laid before a convention expected to be called in 1783 by the legislature for the establishment of a Constitution for the Commonwealth of Virginia. The plan, like everything from the same pen, marks a turn of thinking original, and he's giving credit to Jefferson for the originality of this proposed Constitution that Jefferson has drafted. And this is the particular provision in the Constitution that Madison focuses on as the focus of Federalist number 49. He said his proposition is, and this is a quote from Jefferson, whenever any two of the three branches of government shall concur in opinion, each by the voices of 2/3 of their whole number, that a convention is necessary for altering the Constitution or correcting breaches of it, a convention shall be called for the purpose. What Jefferson is proposing, in order to preserve and protect the principle of separation of powers, is that whenever 2/3 of two of the three branches request a constitutional convention, then that convention must be called. And of course there are many people who are critics of the Constitution who are already beginning to lobby for a second convention, for a new constitutional convention, ostensibly to take up the issue of amendments, a Bill of Rights, because the Constitution does not have a Bill of Rights. And Madison and the Federalists are petrified of a second constitution. They feel like they lose everything they got. So Madison has to take on Jefferson's request or suggestion that a convention be called when 2/3 of two of the three branches of government call it. And then Madison launches into Federalist 49, which is a criticism of the Constitutional Convention as a solution to the problems of any constitution. This is an important paper because in it Madison is forced to walk on eggshells. This is the one where he's got somehow to argue against the right of the people to control government. If the people had the opportunity through their legislature to call a constitutional convention whenever they felt that the Constitution was being violated, which is what Jefferson is proposing, then Madison believes that that would be a disaster. And so he sets up a series of arguments as to why this won't work, why we shouldn't do this. Basically, what he's arguing against is allowing the people to tamper with the Constitution. After he reads Jefferson's proposal, he includes Jefferson's proposal for a convention. Madison says, as the people are the only legitimate fountain of power, and it is from them that the constitutional charter, under which the several branches of government hold their power, is derived, it seems strictly consonant to the Republican theory to recur to the same original authority, not only whenever it may be necessary to enlarge, diminish, or new model the powers of government, but also whenever any one of the departments may commit encroachments on the chartered authorities of the others. So Madison is giving all due credit to Jefferson for the proposal. He's talked about how creative it is. Now he's talking about how logical it is, that in a republic, if the Constitution needed changing, needed tweaking, you would go back to the original source that created it, which was the people. Because government derives its power from the consent of the governed. Therefore, each branch derives its power from the people it governs. So consequently, fixing the Constitution would seem to call for the people to come back into the picture on a regular basis which is what Jefferson is proposing, and this is what Madison has to find a way to derail. He says, and this gives you an idea of how tactical and strategic Madison is. There is certainly great force in this reasoning, he said. And again, he's basically saying this looks like a great idea. It looks like it makes sense. And it must be allowed to prove that a constitutional road to the decision of the people ought to be marked out and kept open for certain great and extraordinary occasions. But there appear to be insuperable objections against the proposed recurrence to the people as a provision in all cases for keeping the several departments of power within their constitutional limits. Now he's going to go through and point out reasons why this won't work. In the first place, he says, the provision does not reach the case of a combination of two of the departments against the third. Basically, it doesn't allow for the fact that two of the departments can join forces in order to oppress the third. Jefferson's proposal doesn't consider that, Madison says. In the next place, it may be considered as an objection inherent in the principle. That is, every appeal to the people would carry an implication of some defect in the government. Frequent appeals would, in a great measure, deprive the government of that veneration which time bestows on everything, and without which perhaps the wisdom and freest governments would not possess the requisite stability. What Madison is saying is, every time you go to the people with a problem in the Constitution that needs fixing, you are weakening people's reverence and willingness to support government. You are jeopardizing government's ability to govern because you're suggesting that there are weaknesses in the system. And the more often you do it, the more weaknesses you indicate there are. And the more frequently you do that, the more it's beginning to dawn on citizens that this Constitution that we are asked to support and give our lives for is really full of holes. It's not worth the support that its supporters are asking that we give it. So that's what Madison says is a second danger. The danger that in frequently going back to the people to come to a convention and fix yet another aspect of the Constitution, you're weakening people's willingness to support and endorse the Constitution itself. And you're making it more and more difficult for government to govern, because people are becoming more and more suspicious of government's very structure. Then he talks about the issue of public tranquility. In other words, we shouldn't bother the people with this. The danger of disturbing the public tranquility by interesting too strongly the public passions is a still more serious objection against a frequent reference of constitutional questions to the decisions of the whole society. By going to the people, what you're doing is you're creating instability when what people are looking for is stability. People value the tranquility. If the government is working, they never see it, they never worry about it, they never think about it. If you're constantly going back to the people, then you're planting the seed in their mind that things are not stable. They are fluid, and they are risky and unpredictable, and all the other terms that suggest the potential for disorder. And so you don't want to do this. The last place you want to go is to the society at large. He says we have to recollect that all the existing constitutions were formed in the midst of a danger which repressed the passions most unfriendly to order and concord. We don't want to inflame those passions now. And then Madison says, but the greatest objection of all is that the decisions which would probably result from such appeals would not answer the purpose of maintaining the constitutional equilibrium of the government. We have seen that the tendency of Republican governments is to an aggrandizement of the legislative at the expense of the other departments. The appeals to the people, therefore, would usually be made by the executive and judicial departments. But whether made by one side or the other, would each side enjoy equal advantages on the trial? Let's view the different situations. The members of the executive and judiciary departments are few in number and can be personally known to a small part only of the people. The latter, the people, by the mode of their appointment, as well as by the nature of and permanency of it, are too far removed from the people to share much in their prepossessions. The former are generally the objects of jealousy, and their administration is always liable to be discolored and rendered unpopular. The members of the legislative department, on the other hand, are numerous. And so what he's talking about is that by going to the people, you are bringing pressure from the people on the legislature to wrest power from the other branches. You are contributing to the literally to the destruction of the principle of separation of powers in government. In order to preserve the stability which separation of powers offers us, you've got to keep the people out of the picture. They don't need to know this stuff. They don't need to have their tranquility disturbed. They don't need to be involved. So what he's doing is tearing apart the proposal that Jefferson made, because Madison knows that in instituting the call for constitutional conventions, you're disturbing the stability, you're making it more and more difficult for government to even work. Then he has a whole paragraph, which I have labeled in my notes in the margin, the danger of a convention. But the legislative party would not only be able to plead their cause most successfully with the people, they would probably be constituted themselves as judges. The same influence which had gained them an election into the legislature would gain them a seat in the convention if it were called. If this should not be the case with all, it would probably be the case with many, and pretty certainly with those leading characters on whom everything depends in such bodies. The convention, in short, would be composed chiefly of the men who had been or actually were, or who expected to be, members of the department whose conduct was arraigned. They would consequently be parties to the very question to be decided by them. What he's basically suggesting is the reality of politics. That if you called a convention, then you'd have elections. And the people who would have the best chance of winning election to the convention would be the best known people that you've already elected to the legislature. So you'd end up putting the same people who are causing the problem into a convention which is supposed to solve it. And so Madison's position is that won't work either. Then he closes Federalist number 49 by talking about the dangers of the people's passion. He says the passions, therefore, not the reason of the public, would sit in judgment, but it is the reason of the public alone that ought to control and regulate the government. The passions ought to be controlled and regulated by the government. Think about what he's saying. He's saying basically that when you're dealing with the Constitution, you've got to keep passions and politics out of it. What you're looking for is reason, logic, common sense, thinking, reflective people who can solve problems. Reason should govern government. Government should govern passion. And if you involve the people in this, you're going to have passion, not reasoning. You're going to have people who are politically inflamed and excited. And the consequence of that is that the convention is going to do something stupid rather than something intelligent, which would be what reason would lead you to. Consequently, in Federalist number 49, Madison has effectively refuted Jefferson's suggestion for calling conventions to address constitutional problems. Notice what he is doing. If you go back and think 47, 48, and 49, what has he done? He is eliminating all the options except the one that he's going to propose, which is Federalist 51, which is guaranteeing the protection of liberty not by separating the branches of government, but by creating a system of internal checks and balances so that no one branch can get power over the others. That's going to be the system of internal stability that the Constitution is based upon. That's the one that Madison wants to defend. But in order to do that, he's got to eliminate all of these other options. And that's what he's doing, paper by paper, is eliminating every other solution except the one that he believes will work. It is an absolutely brilliant, brilliant piece of writing and analysis and thinking, I believe. Federalist number 50 is entitled "The Same Subject Continued with the Same View." So this is the fourth in a series of 5 papers dealing with the principle of separation of powers and the tendency under the Articles of Confederation for legislative branches to seize control over the other branches and thus create the problem. This is one of the major issues that shows up in Madison's Vices of the American Political System. Now he's talking not about frequent appeals to the people. Now he's talking about excuse me, he's talking about periodic appeals to the people. In other words, why not a system where at regular intervals of time conventions are called together in order to look at the Constitution and make revisions? Instead of bringing the people in it when issues are hot and passions are running high, he's taken care of that already. Now he's suggesting, what about the other idea of having regularly scheduled checkups, where a convention would be brought together representing all the, representing all the interests in society. A convention would be brought together, and the people who would be elected would have the job of looking at the Constitution and making sure that it was working and pointing out areas where it might not work. Now he's going to set out to destroy that. And basically what he talks about here, and we're running out of time, so I don't want to get too much in this. This is one of the shortest papers. Federalist number 50 is actually one of the shortest. Basically what he's saying in Federalist number 50, the way he disputes the idea of periodic conventions, periodic reviews, if you will, is politics. The mere fact that you're calling a convention at all means you got to have an election. And the reason is because you're dealing with a convention, with a constitution. And since constitutions derive their legitimate authority from the consent of the governed, then you got to do it through conventions, because that's the only way you can use the sovereignty of the people to justify the constitution you're creating. So you got to have the people involved, but you don't want them involved. So the way you do it is through convention. But he's pointed out that if you have conventions called at the whim of the people, you're going to have all the passions and all the politics involved. So now he's talking about regular periodic reviews, conventions scheduled to come at particular times and look carefully at the Constitution and make sure it's working. And Madison quickly refutes this idea by suggesting that the only people that are going to win the elections to the convention are the same kind of people that caused the problems in the first place. You're going to end up with the same political positions, the same political factions and controversies in the convention that you had in the legislature, or that you had in the state, which caused the need for the convention in the first place. Basically, what Madison is doing is eliminating the idea of a second convention. And I might say, as an aside, that if you are as appreciative as I am of James Madison's intelligence and insight and wisdom, then we all need to take seriously his fear and concern of a second convention. How do you limit it? How do you control it? How do you keep? By definition, once the convention comes into session, it's a whole new ballgame, because the members of the convention are representing the people of the society. In other words, they have been given the power to exercise the people's power to create government. How do you control that? How do you limit it? Once a convention meets, then what you have is representatives of the people evaluating the structure and performance of government itself. And Madison would believe, as do I, that you're asking for trouble, because there's no way to control that. You're unleashing a genie that you can't get back in the bottle. Which is why I am so frightened by Mark Levin's book and Mark Levin's focus on the convention avenue toward the amendments that he proposes and terms liberty amendments. What he's talking about is major structural changes in the Constitution of the United States being conducted, being performed by people who have been given, because they are in convention, have been given the power of the people to literally alter government. And what we are seeing today is that the Tea Party influence over the Republican Party and the Republican Party's success in wresting control of government in state after state after state, they are moving dangerously close to the two-thirds. And one thing we've seen in the debates surrounding the issue of the Affordable Care Act, Obamacare, is the fact that these folks vote in sync. They are in lockstep. None of them ever break free from the pack. We are talking about a highly disciplined movement funded by big money with the all-pressing promise that if you step out of line, we'll make sure that you'll never be reelected. We'll pour money into that state to make sure that you'll never be reelected. So you better go along. And they do. They vote consistently. They vote in sync. They are in lockstep. So consequently, the idea of moving towards the potential of 2/3 of the states being necessary to call a convention, which is what Article 5 of the Constitution provides, in the minds of many of these people is within reach. It's not an objective that is impossible to ever attain. It's one that's getting dangerously close. And what we are seeing in these Federalist Papers is the lengths to which Madison will go in order to make sure that there's not another convention. Because the members elected to the convention will be the political leaders of the state who have caused the problem in the first place. They're going to be, in our case, they're going to be Tea Party people from these states, these 2/3 of the states. And the minute they get in there, the agenda is going to be these liberty amendments. Recall of the Supreme Court, over the ability to overrule the decisions of a Supreme Court, the denial of the people's right to elect their senators and giving it back to the state legislatures, and on and on and on with those amendments. I would suggest to you we don't want to go there. And it's so hard politically to argue against it because it sounds like you're arguing against the ability of the people to govern themselves. But in fact, that's what you're doing. And that's what makes Madison's strategy here so brilliant. He's able to do it and do it in a way. These Federalist Papers appeared in the newspapers. But if one thing has come through as we've gone through these various Federalist Papers, is how difficult they are to understand, how complex and abstract and obtuse they are. And I go back again to Otto's letter to Vergennes about circumlocutions. And other strategies designed to make it very difficult for the average person to understand what they're talking about. But on the other hand, to communicate directly and perfectly with the people who know what's going on. So in Federalist 50, what Madison does is basically argue that you're going to get the same people in these conventions, whether they're periodic and scheduled or whether they're unscheduled and are just called as the need arises. In both cases, you're going to have a group of people who are armed with the power of the people to govern, taking on the Constitution of the United States. In this case, what Madison is talking about is the state constitutions, of course. The Constitution of the United States, he believes, is going to fix these problems. And so finally, what he has done, now he's to 51. What he has done, he has eliminated all the suggestions and other options except the one on which the Constitution is based, and that's the principle of checks and balances. Separation of power is but a series of internal checks and balances which protects individual liberty. I'm just going to read the first paragraph of Federalist number 51. Madison says, "To what expedient then shall we finally resort?" What are we going to do? None of these things will work. "For maintaining in practice the necessary partition of power among the several departments as laid down in the Constitution?" Question mark. What's the answer? The only answer, he says, that can be given is that as all these exterior provisions are found to be inadequate, the defect must be supplied by so contriving the interior structure of the government as that its several constituent parts may, by their mutual relations, be the means of keeping each other in their proper places. The answer comes not from some exterior controls over government. You've got to structure it internally in such a way that while the powers are kept separate, each of them is able to check the others. I apologize for that phone in the background. And that's what you got to do, and that's what he does in Federalist number 51. And if you remember, we covered this before, so I won't go into detail. But if you remember, this is the place where Madison says, "It may be a reflection on human nature that such devices should be necessary to control the abuses of government. But what is government itself but the greatest of all reflections on human nature? If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place oblige it to control itself." And then he goes into the system of internal checks and balances in the American Constitution, which, contrary to the critics, do not threaten liberty, but in effect protect it and guarantee it. And that's this series of Federalist Papers focused on the issue of separation of powers, the idea of dividing government into branches, and then building an internal system of checks and balances. What you have effectively done, without you getting out of the text here for a moment, we've only got about 5 minutes left here in today's program. What you have effectively got here then, it seems to me, is a system which is structured in such a way that governing becomes very difficult. The idea is, the assumption that you can see coming through in Madison over and over again, is the idea that the easier it is for government to govern, the more threatened liberty is. And so the idea is, if your goal is to protect individual liberty, then the way you do it is to set up structure within government in such a way that government action becomes very difficult. It becomes slow, it becomes tedious, and it becomes difficult. And so, in effect, what Madison and the Federalists have done is set up a constitutional system which makes government extremely difficult. Because these people believed, they were not progressives, they did not believe that government had a conscious, visible role to play in the day-to-day operations of society. They defined government's role as being very limited to preserving what Jefferson called in the Declaration of Independence, people's inalienable rights to life, liberty, or property. That's why it was created. That's its specific charge. And anything beyond that, Jefferson says, the people have the right to resume power and abolish that government because it has violated the contract of its own creation, the terms of its own creation. And Madison has told us in these papers what we need to do and why we need to do it. And he points out that all of these other suggestions are external and they won't work. You've got to basically operate from within. You've got to take factions and interest groups not as a challenge, but as a reality. And you've got somehow to find a way that while all of this is going on internally, it's not having an effect on what government does. So, you know, I really think in many ways it's a brilliant system. I don't think we need to lie about it. I don't think we need to artificially try to send the message to youngsters that the founders were gods or demigods or semi-gods or whatever you want to call it. The fact of the matter is they saw a problem, they defined it, and they basically came up with solutions to address those problems. What I would like to close with today, not just today, but close this week's programming with, is the challenge that we currently face to the system that Madison and the Federalists created. Technology has brought us to the point in the 21st century where the kind of intercommunication over large distances, which Madison never conceived of as being possible, has now become possible. We look around the world and we see revolutions and governments being overthrown principally through an internal communication system built on cell phones. And the point I'm making is we are facing a totally different set of challenges. And I personally do not believe that the Constitution as structured is up to those challenges. It's kind of like American foreign policy. For years, Americans believed that we could avoid involvement in European wars and world wars because we had two oceans to protect us and keep us isolated. In other words, the Pacific Ocean and the Atlantic Ocean were kind of our shields. They were our barriers, our protections. They meant that we controlled the level and degree of interaction that we would have for the rest of the world. The world didn't dictate those things to us. We charted our own course in terms of the way we would interact with the world because we had these barriers and these protections. But in today's world, technology has closed the distance between us and the rest of the world. The oceans don't work anymore. Communication is instantaneous. And so many of the issues that we face are breakdowns in a system which Madison believed would be the safeguards to the system he created. Now we're seeing direct threats to that system. An answer? I believe the answer is in the education of our people. Our people need to understand the system. They need to understand how it works and why it works. They need to understand the dangers of tampering with it. They need to recognize the motives of those who would tamper with it. And they need to be able to protect themselves from the appeals and the badgering that they are going to receive from ideological demigods who have an agenda. We've got a big job to do, and we're only beginning. It's 59 minutes after the hour. Bob Kincaid is pacing the floor, ready to get started. So let me get out of here by thanking you for your time today and for your time this week. Please have a wonderful rest of the week and weekend, and we'll be back together on Monday. This is Bill O'Brien for the Virtual Center, thanking you.